Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. And friends, welcome back. We are back here in Calloway County with Kentucky workers' compensation attorney Jeff Roberts. Jeff, how you doing, guy?
I'm doing good, Jim. How are you?
Well, I'm doing well. Always good to see you. Always good to be back in Murray. And today we're going to talk about workers' compensation appeals. And there's a couple of different routes and when these might come up. But you've done this for a long time. You've actually even taken several of these cases up to the Kentucky Supreme Court, which is the highest appellate court, I guess, in the state. So we'll get into that toward the end here as well. Yeah. So why don't we go ahead and open this up? You want to talk about medical benefit decisions?
Yeah. When you talk about appeals, when attorneys talk about appeals, they're usually talking about the appealing of the entire case. A lot of times, though, when I'm talking to the clients, the first time an appeal discussion comes up is in regard to medical treatment. In Kentucky, in a workers' compensation claim, one of the more valuable benefits is the medical, which there's no copays, no deductibles. Insurance company is responsible to pay, all reasonable and necessary medical associated with the work-related injury. But the insurance company does have the right to have the records reviewed to make a determination as to whether the treatment is for the work-related injury or whether the treatment is reasonable and necessary in compliance with the medical treatment guidelines from there. And so normally what I see, or first time I talk to a client about an appeal, is when some medical treatment from their treating doctor has been denied. When the treating doctor recommends treatment with the way health insurances are nowadays, non-workers' comp, but general health insurance, before treatment's carried out, the doctor submits it in for pre-certification, and they want that pre-cert before they engage in the treatment. So they do the same thing with workers' comp. They try to pre-certify the medical treatment ahead of time. And so when they do that, the treatment frequently is sent to what's called utilization review, and that means it's reviewed by a doctor who will look at it and say, yes, this is reasonable and necessary and complies with the treatment guidelines, or no.
And is that an independent physician, or is that somebody who works for the insurance company as well, or kind of how does that play out?
It depends on who you ask. To be honest, most of the utilization review is done by companies contracted with the insurance company to do these, but they do a lot of them for the insurance company. So the company that does them and the insurance company would say they're completely independent. In my estimation, the utilization review company knows that they're doing hundreds of utilization reviews a month for XYZ insurance company, and so they have a financial incentive to try to tell the insurance company what they think the insurance company wants to hear. They're going to say they don't. So, like I said, it depends on who you ask, but they are contracted with the insurance company.
So it's kind of like, it's very similar to what we've talked about in previous episodes with the company doctor, where if the employer says, hey, we understand you're hurt, we're going to help you out, we want you to go see this doc, he'll take good care of you. Again, there might be some kind of informal relationship there, and that comes into play from time to time.
Exactly. It comes into play when you have a quote-unquote company doctor. You get into that situation where the employer may refer a lot of people to that company doctor, and so the company doctor then may provide different treatment, hopefully not, but also may end up coming out and saying the person's injury is not as bad type situation. That's where I tend to see it is they release the person to go back to work much quicker than than another doctor would. Sometimes less likely to recommend surgery for conditions, things of that nature. And in this utilization review, it's kind of the same situation. There's no the contract with the utilization review company doesn't say, you're going to shade this in our favor. I think that occurs. But the insurance company utilization review will always deny that it does occur. But anyway, the utilization review company will review it, and if they deny the treatment, then the first appeal process comes into play, and you have a right. You and your doctor both get a copy of the denial letter, and you have a right to appeal that denial. A lot of times, that first utilization review decision is not made by a specialist in the same area as the treating doctor. So if you've got a shoulder problem and your doctor's recommending, you go to an orthopedic surgeon who's recommending shoulder surgery for you, the doctor who's doing the initial utilization review may be an internist or a family medicine doctor, not an orthopedic surgeon. When you do the appeal of that denial, if it's denied, then it's supposed to go to a specialist that is the same specialist as the treating doctor is in that setting. So if you're seeing an orthopedic specialist for a shoulder problem, then it should go to an orthopedic specialist who treats shoulders to look at it and then make that the second determination on whether the treatment that's being proposed is reasonable and necessary, or is approved or not approved. It can be denied for a variety of reasons. And sometimes, when you get your first denial in, sometimes it is, well, before we can approve this, there needs to be physical therapy performed. And if that doesn't work, then surgery is called for. And then instead of appealing that denial, if I'm representing the client at that point, instead of appealing that, I said, well, let's go to the treating doctor, have him order the therapy, even though he doesn't think it's going to help. Let's do that process because it's going to be better for my client, and usually going to be quicker for them to get to treatment to jump through those insurance company hoops. Health insurance places those same kind of hoops on in cases as well. And, a lot of times the doctors already know what the hoops are and they've already jumped through them before they recommend the surgery, even though they know it may not help because, the person's got an MRI that shows a massive tear. Well, therapy's not going to cure a massive tear, but they still got to jump through those hoops. And so that may be the process instead of appealing, but frequently it is appeal the denial, and then which is asking for a reconsideration. And then if it's denied again from a medical treatment standpoint, it depends on the status of the case, really, on a medical treatment issue. If the medical dispute is before you have an initial determination or resolution of the case, then the next step is to file the claim and get it in front of a judge, for an administrative law judge, to make the determination of whether this medical treatment is or is not reasonable and necessary, or should be found compensable and paid for by the workers' comp carrier. And that can be a very time-consuming process, unfortunately. But that's the next step. Now, if it's post, and that's the injured worker's responsibility to file the claim forms and take that issue in front of the judge.
When you say it's the injured worker's responsibility, is that something you as the attorney would do with them?
Absolutely.
It's on your side, not
yeah,
the other.
Exactly. When I say it's their responsibility, it's the plaintiff's side or the injured worker side, the attorney that represents the injured worker. If it's me or another attorney handling the case, then it's going to be the attorney that files the claim forms and gets the matter in front of a judge. And frankly, a lot of times it's the denial of the medical treatment that causes someone to reach out to an attorney. That's when they say, okay, yeah, I do need an attorney because now they're not paying for my medical treatment. But then you get it in front of a judge. But if it's post-award, if it's after you've already been in front of the judge or you've had the case settled and the settlement approved, or you've gone into a judge's decision, judge ruled in your favor, yes, you suffered a work-related injury and you have entitled permanent disability benefits because of that, and that's become final, and it's after that date that this medical fee dispute, because your medical treatment in Kentucky for a work injury would continue for a minimum of 15 years, potentially a lifetime. So if it's after that, then the burden is actually on the employer to file the it's called a medical fee dispute and a motion to reopen to get the matter in front of a judge, and they have a certain deadline to do so. And if they don't comply with that deadline, then the injured worker and their attorney may be the one that has to file it to get the order, but the order approving should come in fairly quickly because they failed to comply with the deadlines that was on them. And now the treatment, in my opinion, is going to be compensable because they didn't comply and file that motion to reopen within the time frame they were supposed to file that motion to reopen.
Almost like a statute of limitations.
Very much like a statute of limitations, yes. And so you've got that, with the medical fee issues, that's frequently, or medical treatment issues, that's frequently where I first have the conversation with the clients about appeals and that appellate process, so to speak, for those things. The other appeals that we talk about, when attorneys talk to among themselves about an appeal, they're talking about appealing the judge's decision, not the doctor's decision on medical treatment, but the administrative law judge's decision in the case. And a lot of times there's a variety of issues. The judge may, when they decide the case, may be deciding 5, 6, 7 different issues that present in that case. So you may be successful on some and not successful on others. So the judge may find that, yes, you suffered a work-related injury and are entitled to the medical treatment, but you're not as disabled as you were arguing that you were. So I'm not going to award as much as we thought we should get in the case. Or they may find that it's not a work-related injury. So in that situation, then you can appeal the administrative law judge's decision. Both sides can appeal. So if you're successful, if the injured worker is successful, their attorney is successful and gets everything they're asking for, the employer can appeal it. If it's dismissed by the administrative law judge, or you don't get everything you think you should, and you think you have a legitimate basis, then you can appeal it. In a workers' compensation case, the appeal then goes initially to the Workers' Compensation Board, which is a 3-member panel. It's the same 3 every time, and all they do is handle appeals, workers' compensation appeals from administrative law judges' decisions. And one of the differences between the appealing the medical fee dispute, the initial medical fee dispute, to another doctor, and appealing that second denial to a judge and taking it in front of a judge, is in that process, when you, on the medical fee issue or medical treatment issue, when you ask for reconsideration, it goes to a different doctor. That new doctor is not looking at it and saying, did the first doctor that decided this was not compensable, did they decide it, did they do what they were supposed to do? The second doctor is looking at it completely, is not supposed to give any weight whatsoever to the first doctor's opinions and make a new determination: is this treatment compensable, or should it be compensable? And then when you appeal that denial to the judge is looking at it and saying, is this treatment compensable? Now, the judge may consider those doctors' opinions, but he's going to consider other things as well, and he's making a completely new determination that is his or her, it could be a female judge, his or her determination on whether the treatment is compensable or not. Now, once the judge decides the case, whether it's just a fee dispute or whether it is the entirety of the case, the appeal to the Workers' Compensation Board is a different type of appeal, because they're not looking, the Workers' Comp Board is not going to be redeciding the whole case at all. They're looking at it and looking, did the judge commit a legal error, or did the judge commit a flagrant have a misunderstanding of the facts, and that substantial evidence doesn't support the judge's decision. So they're looking at it from a completely different standpoint. They're not redeciding. They're saying, did the judge commit some sort of an error when the judge decided the case?
So you're appealing factors. You're not appealing the entire case, and they're going to decide on those factors versus going back to say, okay, let's start all over.
Correct. So, yeah, if in a case, if the judge were to say, yes, this is a work-related injury, you're entitled to the medical treatment, all the medical treatment that was challenged in the case. But you claimed you were off work and entitled to what's called temporary total disability or lost wage benefits from the date of the injury until 1 year after you had surgery. And the judge could look at it and say, well, I don't think it was that long. I think, 4 months out from surgery, you had recovered enough that you could return back to work and were at maximum medical improvement. So this other 8 months that you're asking for in temporary total disability benefits, I'm not giving you, and you're claiming you're totally disabled from this injury. I don't find you're totally disabled. I find you're just partially disabled. Well, the injured worker can go up on appeal on not giving the entirety of the 1 year after surgery of temporary total, but only giving 4 months. So that other 8 months of benefits, they can take that up on appeal, and not finding the injured worker totally disabled, they can take that up on appeal. And if the injured worker is the only person who appeals, those are the only two issues that the workers' comp board would be deciding. And then if it goes up further, which we'll talk about in a second, it stays limited to those two issues. Now, the employer could also file an appeal to the workers' compensation board to challenge whether the condition is work-related, and then the board would decide that. They're not making a new decision. They're just looking and saying, did the judge commit an error, some sort of legal or factual error in ruling on that case? And so but if both sides can appeal, so the employer can appeal the things they lost on, the injured worker can appeal the things they've lost on, and if all the issues are appealed, then the workers' comp board will address those. But it's only the issues that are appealed that they can address.
And so, is it different going to that first appellate level? Is it more briefs or is it oral arguments? I mean, kind of how does it? You're standing in front. I picture that there you are at a podium standing in front of three judges talking about the case.
In workers' comp, that's rarely happens. It can, and I have done that once in my career, and actually maybe one of the few times that the workers' comp board ever had oral arguments, because they rarely do oral arguments. But it's normally all written, and there's no new evidence. I didn't mention that before. Yeah. On the medical part, when it goes up for reconsideration, the doctor can submit more evidence and say, well, the initial doctor said we needed to do 6 weeks of physical therapy. Apparently, he didn't have the records where we've already done 6 weeks of therapy. Here are those records. And so the new evidence can be submitted there when it goes in front of a judge. If you appeal that, take that second denial to a judge, you can submit all the evidence you want to the judge. Once a judge makes a decision, whether it's on medical or the entirety of the case, when you take the appeal at that point, the appeal is just based on the record the judge had. You cannot put new evidence in on appeal to the workers' comp board or any other appellate level above the workers' comp board. So they are limited to that, and since there's no new evidence, usually the appeal to the workers' comp board is strictly in writing. It's normally you file a notice of appeal, and then you file a brief to the workers' comp board, which is basically kind of like it's just a written argument of why the board should rule in your favor. The other side files a response, and then the board makes a decision. And in that regard, I think you do get a chance to file a reply, I believe. And so, but it's all written. The board can order oral arguments if they want to have oral arguments. It's a rare occurrence, as I said, but they do. But that's completely in the board's discretion. So, if the attorney asks for oral arguments, the board can look at it and say, no, we don't want to have oral arguments. If the attorney doesn't ask for oral arguments, the board can look at it and say, I think this is the case, we need oral arguments, and they can order that. So,
Let me ask you this: the 3-person appellate board for at that level, can they refuse to hear an appeal? I mean, can they say no, it's not appealable if that's a word?
uh,
Do they have discretion at that level?
yes and no. The
I'm sorry if I threw you a curveball.
No,
on this,
no,
but-
you didn't throw me a curveball, but the way you phrased the question, I've got to say yes and no. They can say that the case cannot be appealed yet, because to file the appeal in a workers' compensation case, to the workers' comp board, the judge is supposed to have ruled on all the issues. So if the judge, and this occurs sometimes, is we take there's an issue, a legitimate issue, on whether the condition is work-related and the person's entitled to medical treatment. And until the person gets medical treatment, we don't know whether what their permanent disability is going to be from the injury. So a lot of times you kind of separate the case in front of the administrative law judge, called bifurcating the case, and you have the judge decide whether this is a work-related injury and if the person's entitled to medical treatment and benefits for being off work while they receive that treatment. And when the judge does that, if he rules in the injured worker's favor, he hadn't ruled on everything. He hadn't ruled on permanent disability benefits or anything else. So that ruling cannot be appealed. It's called an interlocutory ruling because it has not resolved everything. It just resolved part of the case. And so if the employer appeals that ruling, the workers' comp board can and should deny that and say, no, we're not hearing this appeal yet because it's not a final decision yet. And frequently, if the employer does that, the attorney for the injured worker will file a motion to the workers' comp board saying, this is not a final opinion, it can't be appealed, you need to dismiss this appeal, which they should grant. Sometimes they wait until it's briefed before they rule, so they can make sure they let the employer argue their position, so to speak. But once it is a final decision, they cannot then say, once the judge has ruled on everything, they cannot then say, no, we're not going to hear this appeal. They can and frequently do say, the judge got it right, and we're not going to disturb what the judge did on appeal. But they can't, once it's a final decision, if it is appealed, they've got to look at that appeal and then make a determination then. So.
Okay, so that's the 3-board panel, if you will.
Correct.
That's at the second level. Now there is another level.
Correct.
And
There's
this
two
is
more levels.
2 more levels. Okay, so let's jump in.
The administrative law judge and the workers' comp board are all employees of the Department of Workers' Claims in Kentucky. They're all part of the administrative process. So once the workers' comp board rules, then either side that can file an appeal to the next level, which the next level is the Kentucky Court of Appeals. One difference between the Kentucky Court of Appeals and the Workers' Comp Board, like I said before, the Workers' Comp Board only hears workers' compensation cases. They don't appeal. They don't decide criminal cases. A felony case in circuit court that is tried and then goes up on appeal. Workers' Comp Board does not hear those type of cases. The Court of Appeals does. The Court of Appeals hears appeals of any type of case, pretty much. And so the Workers' Comp Board and the Court of Appeals are different in that regard. Plus, how they become a Workers' Comp Board member or how they become a Court of Appeals judge is different. In Kentucky, our Court of Appeals and Supreme Court justices are elected positions, and it's broken up by into different Supreme Court districts. You've got first district, second district, and there's 7 districts. And each district has their own Supreme Court judge, and I believe each district has 2 appellate court judges, Court of Appeals judges. And so the Workers' Comp Board are actually by appointment by the governor, and they become a board member by appointment of the governor and confirmed by the Senate. So it's kind of somewhat like federal judge process in federal court. President makes the appointment, the Senate confirms the appointment, and that's kind of the way the Workers' Comp Board is here. Only it's the governor and the Kentucky Senate doing that. And when the case goes to the Court of Appeals, then there's a 3-judge panel that decides it, but you don't know which 3. It's whichever 3 are up at that point in time when the case gets appealed. So it could be assigned to a judge from the 1st district, 5th district, and 7th district, or 2 from the 1st district, 1 from the 4th. You don't know which judges are getting the case. It's on a rotating basis to some extent. From there, and so, but it goes up to appeal again. It is, and they're looking at it from the standpoint of, did the Workers' Comp Board commit an error in the way they ruled on their appeal? So it's not, you don't submit any new evidence. It's all pretty much in writing. Now, the Court of Appeals can have oral arguments and will more likely have oral arguments on a matter than the Workers' Comp Board will. From that, so the court may say, yes, we want to have oral arguments. Again, it's their decision on whether they do or don't. But even then, you still have the written arguments, and then the oral arguments are for them. You present your case. Anything that they want develop further is the reason they will do the oral arguments and ask questions to develop the record further to help them understand it before they decide the case. And then they're, again, looking at it from the standpoint of, did the Workers' Comp Board commit an error in the way they ruled on this case? Or is there, the Workers' Comp Board will decide legal issues, but if it's a legal issue that's not been decided by the Court of Appeals or the Supreme Court in a published opinion before, then on legal issues, they're not giving deference to what the Workers' Comp Board did. They're looking at it. I mean, they may look at how the Workers' Comp Board ruled on that legal issue, but they're making the determination of, okay, is that really the way this legal issue should be resolved? And so they're not giving deference. They're looking at it and saying, that's how they resolved it. We think they did it right, or we think they did it wrong, and this is how it should be resolved. So, like, a few years ago, we talked about this, I know, in previous, I don't know if it's podcast or video episodes or what, but in 2018 they put in a law capping benefits at age 70, and there was constitutional challenge on whether they could do that or not. The board doesn't make constitutional determinations, so the board couldn't rule on that issue from there, and then it would go, so but the judge had to make a ruling on that issue. To some extent, they would say, well, we can't decide constitutional stuff, but then they say, but we're going to apply the statute as written. We're not going to declare it unconstitutional, so they apply it. And then the Court of Appeals looks at it and says, this is or is not constitutional from there. So you've got some issues that are first addressed, really, at the Court of Appeals level if it's a constitutional magnitude issue.
Okay. So you get this going up, and this is yet another round of appeals that goes on. Does the workers' compensation attorney get paid extra for going to the appeals? Or I know typically the workers' compensation attorneys have a capped fee, and that's done by Kentucky statute. How does it happen when it goes up on appeal? I mean, it seems like you're doing a lot more work, basically.
The attorney representing the injured worker generally is working on a contingency fee basis. That's the way I nearly always work on these cases, is on a contingency fee basis, which means I get paid based on how well I do for my client. It's a percentage of the recovery I make for my client. So if we take the case up on appeal, in the case, I don't get paid extra for that. Now, it could result, if on appeal I get more money, like in that one case, one example I gave where, the judge didn't find my client totally disabled. If we go up on appeal and they say the judge erred in that ruling and has to redecide, and it goes back down, and the judge says, okay, yeah, I see where I made that error. The person is totally disabled. Well, what I've recovered from my client has gone up because of that appeal, so my attorney fee goes up as a result of that, but not I don't get paid hourly, so the
Right,
work at the
right.
Court of Appeals or the board, the Court of Appeals, or the Supreme Court doesn't factor in. I don't get more money unless it ultimately results in a better award for my client.
So the
The other
percentage,
side,
percentage didn't change. The bucket just got bigger.
the bucket got
Yeah.
exactly, yeah,
Okay.
and now on the other side, the employer's attorney works by the hour. So on the appeal process, they do get paid for the time they spend on appeal in that situation. So
Okay. Okay. And actually, friends, if you're interested in learning a little bit more about that, if you go back to episode 56, Jeff did an entire episode on contingency fees and his arrangement, his personal policy, which in my opinion, goes above and beyond what a lot of the attorneys are required to do. So some really good information there in episode number 56. So, Jeff, you said there is yet another level appeals, and this is the one that not a lot of people have the experience you have at. So, let's talk about the Kentucky Supreme Court.
Kentucky Supreme Court, yes, I've been to the Supreme Court several times. In fact, not only it wasn't a workers' comp case, but I was licensed, became licensed to practice in 1992. Was sworn in October of '92, and I spent Christmas Day here at the office working on a Supreme Court brief on a premises liability issue for the attorney that I was working with at the time. So within a couple months of practicing, I was doing work at the Supreme Court as far as that goes. But I've been to the Supreme Court multiple times in my career, mostly on workers' comp issues, on other issues as well, but mostly on workers' comp issues. Usually, the normal process for a case, not a non-workers' comp case, is the circuit court handles it, and then the appeal goes to the Court of Appeals, and then you have to file what's called a motion for discretionary review to take it to the Supreme Court, and the Supreme Court can say, yes, we're going to hear that case, or no, we're not going to hear that case. And the Kentucky Supreme Court has that discretion. I mean, they can deny hearing a case. But in workers' comp, they don't have that right. Kentucky's Constitution allows you to have at least one appeal from a lower court. Well, the workers' comp board and the administrative law judge are not courts. They're the administrative process. So the first true court decision is the Court of Appeals decision. And since that's the first court decision and Kentucky's Constitution says you have at least one appeal, then the Supreme Court cannot say they can't deny discretionary review because there is no discretionary review. It's an automatic appeal. You have an appeal as a matter of right to the Kentucky Supreme Court. So you see workers' comp cases go to the Supreme Court sometimes a little more frequently than other cases because they can't deny discretionary review. And so, which one of the reasons why, with as much workers' comp as I do, that I've been to the Supreme Court as frequently as I have from there. So you take the case up to the Supreme Court. Supreme Court then is looking at if it's a constitutional magnitude or if it is determining for the first time how a statute should be interpreted. They're making their own decision on that. They're not giving any deference to what the courts below have done on those issues. But if it's on factual issues, then they're giving a great deal of deference to what the courts below have done. And frankly, unless you're arguing for law, the way they've previously interpreted a law should be changed, that they should overrule their prior rulings on something, it's really hard to get them to address anything that the Court of Appeals and the board has already sustained, because the board looks at it. Did the judge do what the judge was supposed to? The Court of Appeals says, did the board do what it was supposed to? In saying the judge did what they were supposed to. And so the Supreme Court limits their review to basically if it's constitutional magnitude or gross injustice, and it's that's a high burden to be able to be successful at the Court of Appeals. At the Supreme Court.
At the Kentucky Supreme Court. And in fact, if you go back to episode 19 and then again episode 14, Jeff has talked about some of the cases he's been involved with that actually went to that level. So it's kind of nice to know that if you're going to hire an attorney to handle your case, Jeff's one of those guys that can and will and does take it all the way if need be. And it's you developed quite the reputation on that. And in fact, some of your colleagues have actually asked you to come in and assist with a case that may be going to the Supreme Court.
I have, yes, I've been asked to come in and work at the appellate level in that regard on workers' comp and other issues as well. From that standpoint, sometimes I've been asked by different organizations to write what's called an amicus curiae brief, which is a friend of the court brief, which is filed by parties that have an interest on the matter that's been decided by the Supreme Court or potentially Court of Appeal, but normally it's at the Kentucky Supreme Court that you see those briefs filed. And, if you're deciding an issue regarding how car insurance should be interpreted in Kentucky, well, obviously other insurance companies besides the insurance involved in that case are interested in the outcome of that case, and other attorneys who represent injured parties are interested in the outcome of that case besides just the attorney who's representing that one injured party in that case. So frequently you'll see friend of the court or amicus curiae briefs filed in those type of cases, and I've been asked and have filed amicus curiae briefs several times at the Supreme Court on various issues, premises liability, automobile, workers' compensation, all of those type of issues. I've written briefs to the Supreme Court from that standpoint. Just got either into August or sometime in September. I can't remember exactly when the opinion come in, but recently wasn't an amicus curiae, but it was a workers' comp case that I had that the other side appealed that received an opinion from the Supreme Court ruling the way I wanted them to rule in that case and expected them to rule. Yeah.
Congratulations. Well, Jeff, if somebody's sitting there going, I need an attorney that obviously knows workers' comp, I need an attorney who's willing to take on a case and take it as far as we can, how would they get in touch with you?
Best way to reach me is by phone. And frankly, I prefer conversations with people over computers and typing and things of that nature. So you can reach me by phone. I have an office in Murray and an office in Hopkinsville, but I use one phone number so that people can reach me, and that's 270-753-0053. If you want to use an 800 number, I do have an 800 number, 1-800-844-5108. You call that number, and unless it's an extremely rare occurrence, you're going to have a live person answer that phone. If I'm available, I'll talk with you then. If I'm not available, they'll get me the message, and then we will try to talk about your case at that point in time. So.
Outstanding. And you mentioned your Calloway County office and your Christian County office, but in reality, if it's a workers' comp case or a personal injury case, you'll handle them from anywhere in the state, right? I mean, you've got the ability to do that.
Yes, I handle cases all over the state. The majority of my cases are in Western Kentucky, where I am located, but I get asked to come in to get involved in cases all over. I've got several cases in the Bowling Green area now. I've got several cases in Louisville going at this point in time as well. And so I do handle cases all over Kentucky. I've handled them, frankly, from Pikeville to Paducah and from Covington to Paducah. From that standpoint, so yes.
Okay, outstanding. Well, Jeff, obviously you're a busy guy, so I do appreciate your time today. I hope the audience found it insightful. Hope they found some information definitely helpful in understanding what is this whole appeals process. What's it like in the world of workers' comp? And I think you did a great job just kind of explaining that for us.
Absolutely, and if you're going to have to appeal the case, you definitely need an attorney. Can you appeal it without an attorney? Yes. Are your chances of being successful as high as if you had an attorney? Absolutely not.
Well, that's kind of the reason we don't do our own dental work these days.
Correct.
So there you go. All right, my friend. We'll talk to you here in about 2 weeks. Take care.
Thank you.
Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.